In the previous section, we explored the critical differences between community property and sole and separate property, focusing on when and how real property is classified based on timing, intent, and the use of marital funds. Now, building on that foundation, this section examines what happens when one spouse, acting alone, attempts to sell, encumber, or otherwise contract for the disposition of property that is legally held as community property. This scenario is common in real estate practice, and it presents significant legal and contractual consequences under Arizona law. Because Arizona is a community property state, the law presumes that both spouses have an equal, undivided one-half interest in any property acquired during marriage. Under ARS, paragraph 25-14C, both spouses must join in any transaction that involves the sale, conveyance, or encumbrance of community real property. This statute protects each spouse's ownership rights by preventing one party from unilaterally binding the community in major property decisions. It also ensures that buyers and lenders can rely on clear title once both signatures are present. When only one spouse signs a purchase contract to sell or otherwise transfer community property, the contract is not void, but it is voidable, meaning it cannot be enforced against the non-signing spouse. This distinction is crucial. The signed spouse has entered into a binding agreement on their own behalf, but since they do not own the full interest alone, they cannot deliver complete title without the consent of their spouse. The non-signing spouse retains the legal right to approve or reject the transaction, and until both have signed, the contract remains incomplete and unenforceable against the community estate. Example scenario. Consider a married couple, Michael and Teresa, who own their home in Scottsdale as community property. Without discussing it with Teresa, Michael signs a purchase contract to sell the property to a buyer named Anna. Anna believes she has a valid contract because Michael appears on the deed and presented himself as an owner. However, when the transaction reaches escrow, the title company discovers that the property is community property, and Teresa has not signed the contract. Under ARS, paragraph 25-14C, 1. The sale cannot proceed unless Teresa also signs. If she refuses, the transaction cannot close, and the buyer cannot compel performance. In this example, the contract is voidable because Michael's signature alone does not convey Teresa's interest. While Michael may be personally liable for breach of contract to the buyer cannot force the sale of the property since title is incomplete without Teresa's consent. The law safeguards Teresa's ownership rights and prevents her community interest from being conveyed without her approval. Legal authority and case law. The Arizona Supreme Court has reinforced this principle in several cases. In Rodiek v. Rodiek, 1955, the court held that a husband's attempt to sell community property without his wife's consent was unenforceable against the community, as both spouses must participate in any transaction affecting community assets. Similarly, in Rundle v. Winters, 1958, the court emphasized that any contract attempting to transfer community real estate without joint consent is voidable at the option of the non-signing spouse. These rulings underscore that even though one spouse may appear to have authority, Arizona's public policy favors the protection of marital property and the equal interests of both spouses. The court's reasoning reflects the state's commitment to preserving fairness and mutual control in property matters within marriage. Implications for buyers and licensees. Real estate licensees must exercise due diligence when dealing with married sellers to ensure that both spouses are aware of and have signed the contract. Under Commissioner's Rule R4-28-1101A, licensees are required to act with reasonable care, honesty, and competence, which includes verifying that the seller has the legal authority to convey the property. If an agent fails to confirm spousal consent and proceeds with a transaction signed by only one spouse, they risk violating this rule and exposing themselves and their brokerage to potential liability. For buyers, the risk lies in assuming that a signed contract by one spouse automatically guarantees a valid sale. Title companies will not insure title unless both spouses have executed the conveyance, and lenders will not fund loans secured by incomplete ownership. To mitigate these risks, buyers should ensure both spouses sign all sale documents and escrow instructions. Special considerations in divorce or separation. During divorce or legal separation, community property remains jointly owned until a final decree divides the assets. Therefore, even if spouses live apart, one cannot unilaterally sell community property without the other's consent. Only when a court decree or property settlement agreement grants exclusive control can a single spouse act independently. This principle was affirmed in Thomas v. Thomas, 1980, where the court ruled that a husband's attempt to sell community property before the divorce decree was finalized was invalid without his wife's signature. Practical example: imagine a buyer entering into a purchase contract for a Chandler home owned by married sellers, Stephen and Rachel. Stephen signs the contract while Rachel is traveling abroad and unaware of the sale. When Rachel returns and refuses to sell, the buyer threatens to sue for specific performance. However, Arizona law supports Rachel's right to withhold consent. The buyer cannot compel the sale because Stephen's signature alone did not bind Rachel's interest. The buyer's only recourse may be to recover earnest money or pursue damages against Stephen for misrepresentation. This example highlights the importance of verifying all signatures on community property transactions and underscores the role of escrow and title professionals in catching these issues before closing. Discussion: why can a contract signed by only one spouse for community property be considered voidable rather than void? Answer: because one spouse's signature can bind their own interest but cannot convey the other spouse's half. The contract remains unenforceable until both agree, making it voidable at the option of the non-signing spouse. What statute requires both spouses to join in transactions involving community real property? Answer: ARS, paragraph 25, 2114C, which mandates mutual consent for the sale, encumbrance, or conveyance of community property. What responsibility does a real estate licensee have when representing married sellers? Answer: the licensee must verify that both spouses are aware of and have signed the contract, ensuring the seller has legal authority to convey the property and avoiding violations of Commissioner's Rule R428-1101A. Review summary: when real property is held as community property in Arizona, both spouses must sign any purchase contract, deed, or encumbrance for the transaction to be valid. Under ARS, paragraph 25-214C, neither spouse may act alone to sell or bind the community property, ensuring mutual consent and protection of ownership rights. A contract signed by only one spouse is voidable, not void, and unenforceable against the non-signing spouse. Case law such as Rodiek v. Rodiek, 1955, and Rundle v. Winters, 1958, reinforces that community property transactions require both spouses' participation. Licensees must confirm spousal consent to comply with Commissioner's Rule R428-1101A, and buyers should always ensure that both owners sign the purchase contract before proceeding. Understanding this legal framework protects all parties from disputes, title issues, and unenforceable contracts.